Hi, I'm Emily, and I am here with Maya Murphy's attorney, Lauren MacDonald. Attorney MacDonald practices at Maya Murphy's Westport, Connecticut office and is admitted to practice law in both Connecticut and New York. My question today for Attorney MacDonald is, where will my child be deemed a resident if I am a divorced parent? And what if my child lives with other family members or friends?
Hi, Emily. These are great questions that I'm often asked. Thank you. First, if your child is a part of a family in which you are married to or live with your child's mother or father, your residence will be deemed your child's permanent residence. Questions like yours, Emily, may arise when you are a divorced parent and your child spends equal time residing at each parent's home. Under these circumstances, your child will be able to attend school in the school district in which either parent resides. If your child confirms living with both parents, it is likely that the school board will allow you to choose the school district your child will attend, even if your child may only spend half the time in that residence. There are circumstances in which your child may maintain residency and attend school in a school district in which neither one of his or her parents resides. Under these circumstances, it must be determined when your child established this permanent residency. Connecticut law states that children residing with relatives or non-relatives, when it is the intention of such relatives or non-relatives, and the children or their parents or guardians, that such residence is to be permanent, provided without pay, and not for the sole purpose of obtaining school accommodations, they shall be entitled to all free school privileges according to the resident children of the school district in which they reside. This Connecticut statute confirms three key elements. First, the residency must be intended to be the permanent residency of your child. Although there is no clear-cut definition as to what this entails, there are certain factors that the state has set forth that may be relevant in determining whether this residence is in fact intended to be your child's permanent place of living. These factors include where the majority of your child's clothing and personal possessions are located, where your child may have a library card, where your child may attend religious services, the place of any club affiliations, for example, Cub Scouts, Boy Scouts, etc., where your child spends substantial time when school is not in session, and the place where your child would go if he or she left or was not permitted to attend school. Second, the provided without pay provision within the Connecticut statute was enacted to avoid payment to relatives or non-relatives, simply to enable your child to attend a certain school. Lastly, the not for sole purpose of education provision was enacted to preclude your child from residing in a particular school district with the sole benefit of obtaining a free education. In order to make sure that these statutory requirements are satisfied, school districts may require submission of certain documentation as proof, or may even request a signed affidavit attesting to pertinent facts in support of compliance with this law. Now, in New York, a non-parent who is not a legal guardian or custodian, but has assumed caregiving responsibilities, referred to as a kinship defacto custodian, may enroll a student if he or she is designated as a person in a parental relation by the parent of a student. Any designation may not exceed 6 months and must not be in contradiction with any prior order from any court in any jurisdiction that would prohibit the designating parent from exercising the same or similar authority. If the kinship de facto custodian lives in a different school district than the child's parent or legal guardian, he or she will also have to prove residency. If the parent or legal guardian cannot be found, it may be possible to enroll the child after proving residency by affidavit. Under New York education law, certain circumstances where parents cannot assume school responsibilities will qualify a caregiver as a person in parental relationship, and such persons can enroll a child in school so long as they can prove that the child resides with them. If the parent or legal guardian of the child is not in the child's life, then another option may be for the child to become an emancipated minor. Emancipated minors are able to enroll themselves in school. A student becomes emancipated if he or she is beyond the compulsory school age of 16, is not in need or receipt of foster care, is living apart from his or her parents, and does not accept any financial support from his or her parents. If you have any questions about your child's residency requirements, please feel free to give me a call.
Attorney MacDonald is available 24/7 and can be reached by calling 203-221-3100. You can also email Attorney MacDonald at lmacdonald@mayalaw.com, and please visit mayalaw.com for more information.